Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Each month, I'll provide an update on the latest developments that matter to you, and we'll be joined by an expert to take a deep dive into a key corporate law topic. Hi everyone, so this month we've got 3 cases to look at, all of which have, I think, some interesting practical implications for us. So the first one relates to directors' duties. And I think it's pretty well understood that directors owe fiduciary duties to the companies to which they are appointed. But to what extent do those duties continue after the company has entered liquidation and a liquidator has been appointed who's managing and controlling the affairs of the company? Well, this was the question that the High Court had to consider in a case which arose out of an application by the liquidators of a company that was incorporated actually in the British Virgin Islands. So the only directors of this BVI company were Sheikh Mohammed bin Issa Al Jaber and his daughter. And according to evidence that was given in proceedings against the Sheikh by Standard Bank plc in 2011, the BVI company's total assets were about 4 billion US dollars, and it had an annual net income of just over 300 million US dollars. But the company was wound up in October 2011 pursuant to an application that had been made by UniCredit Bank Austria, to whom the BVI company owed over 4 million euros. But interestingly, the 2 directors, so the Sheikh and his daughter, continued in office after the liquidators had been appointed. So, amongst other things, the liquidators challenged a transfer of shares in the company's subsidiary for no consideration that had been made by the directors in 2016, obviously sometime after the company's liquidation. The liquidators argued that the Sheikh had continued to act as if he were the controlling mind of the company, and that he continued to deal with the company's assets as if they were his own, despite the fact that, since they were appointed, the liquidators were the only persons with a right to custody or control of the company's assets. So when it came before the court accepted that where a director has obtained custody and control of a company's assets, and that custody and control crucially continues after liquidation, then the director's obligations of fiduciary stewardship in relation to those assets were capable of continuing post-liquidation. But the judge recognised that the obligations continued in what the judge said was a much reduced form, and only in circumstances where unauthorised dealing with company assets occurs. So the existence of the post-liquidation obligation was rooted, it was said, in the director's original assumption of responsibility as fiduciary steward for company property. So it was the director's control over that property that meant this post-liquidation obligation continued. So the judge noted that a director shouldn't really retain a company's property post-liquidation, but if they did, then they would continue to hold it in a fiduciary capacity. And if the director then dealt with that property adversely to the liquidation, then they will have breached that fiduciary duty and they must account to the company for the property as if the director were a constructive trustee. So in this case, the judge made an award of over 67 million euros against the Sheikh for the misappropriation of the company's property as a result of that share transfer that took place 5 years after the liquidation. So the judge did comment in this case that it would be surprising if the liability of a director for misappropriation of or unauthorised dealing with the company's assets ceased simply because the relevant act took place after the liquidation of the company, despite the fact that the director actually continued to be a director. But the judge was also clear that whether or not the liability existed in each case would depend on the specific facts and the relationship between the relevant parties. So the driving factors here were the fact that the directors remained in office post liquidation and the fact that they were still exercising that custody and control over the company's assets. And because they were doing that, they were still subject to their fiduciary duties post liquidation. Now, I did say that this decision related to a BVI company, and obviously it was decided under BVI laws, but the experts involved didn't suggest that there was any difference between BVI and English law on this particular point. And in fact, the case was decided based on English authorities. So it seems likely that the English courts would take a similar approach in relation to an English jurisdiction decision in the same area. Okay, so the next case concerns the requirements for the valid attestation of a deed by a witness. So here we're back in the High Court again. The High Court held that a deed of guarantee had been validly executed where the three defendants' signatures had been witnessed by the same person who signed only once and signed just under words that said witnessed by. So it's quite a useful case because it gives us some helpful guidance on the requirements for valid witnessing and attestation of deeds. There are actually relatively few things that have to be done by a deed, but where a deed is required, then to be valid, there are various key requirements that have to be complied with. And one of those is that the document has to be validly executed as a deed. So the law says that where an individual is signing a deed, then the individual must sign in the presence of a witness who attests that signature. But it doesn't actually say what attests means, what's involved in attesting a signature. Um, but it's generally accepted that what that requires is the witness to observe the document being signed by the signatory and the witness to then add their signature to a statement that the document was signed by the signatory in the presence of the witness. So we tend to refer to that as an attestation clause. So the witness has to be there, has to see the signatory sign, and then they have to sign themselves next to a statement confirming that they did do that. And why does this matter? Well, it matters because if the requirements relating to witnessing or attestation are not met, then the document will not have been validly executed as a deed, and so it can't take effect as a deed. Although there may be circumstances in which it can still take effect, but just as a simple contract. So, in this case, the court had to decide whether a deed of guarantee that had been signed by the three defendant guarantors was validly executed as a deed. So, the defendants claimed that by failing to comply with the witness and attestation requirements for a deed, the guarantee had been invalidly executed. And they said that meant that the guarantee could only take effect as a simple contract, and that meant that any claims under it were subject to a 6-year limitation period rather than 12 years, which is the limitation period that applies for a deed. So basically, the defendants were trying to avoid their obligations under the guarantee by saying, well, it wasn't a deed, it was just a simple contract. So you had to bring a claim within 6 years and you're out of time to bring a claim. So the court found that the guarantee had, in fact, been validly executed as a deed in circumstances where a single witness had observed the defendant signing and had then signed herself under those words witnessed by to confirm that she'd witnessed the signatures. So the court gave a little bit of guidance in relation to this. It said, in relation to the validity of the attestation, it didn't matter that there were no words confirming that the witness had observed the act of signing, witnessed all three signatures, or signed in the defendant's presence. There was no legal requirement for the attestation clause to include specific words, and it was enough that the witness had signed underneath those words that just said witness by. The court said a witness signing under the words witness by and below 3 signatures clearly attests them all. And again, the law doesn't prescribe a particular form of attestation where several parties were executing a deed. So a person who witnessed several signatures on a deed could indeed properly attest them all collectively by a single signature and didn't have to actually separately witness each signature. And then finally, the court said, well, the law doesn't require the witness to attest in the signatory's presence, nor to do so at the same time as the signatory signed the deed. So effectively, the signatories have to sign in front of the witness, but as long as the witness observes them doing that, the witness can sign sometime later and not necessarily with the signatories still there. So, as I say, failing to comply with the execution requirements for a deed can have pretty dire consequences for a party wanting to enforce any of its terms. And I think although this case does helpfully confirm that valid attestation doesn't require the use of specific words or indeed for each party's signature to be individually attested, I would say that probably best practice is to make it as evident as possible that all the signatures have in fact been properly validly witnessed and attested. And so, therefore, I think ideally, in order to avoid ending up in court and featuring on a future edition of this podcast, it would be advisable, really, for the witness to separately attest each party's signature and for the attestation wording to indicate that the signatory signed in the presence of the witness. Um, Individual attestation can be particularly important where there are multiple signatories to the deed and each party's signature and that of the witness don't appear on the same page. So in this case, although there were 3 signatories and then just one witness, they were at least all on the same page. I think possibly had the signatures been spread out over multiple pages and then the witness had just signed under that witnessed by, on one page or on a separate page, then possibly it might have reached a different decision. But as I say, best practice, as ever, is to be as clear as possible as you can in the signature and attestation block in order to avoid there being any ambiguity and any argument about whether or not the document's been properly witnessed and attested. Okay, so the final case this month involves a claim for unfair prejudice. So this is a claim that a shareholder can bring where they believe that the company's business is being carried on in a manner which is unfairly prejudicial to their interests. And it's there to help protect a minority from abuse by a majority in control of the company. But actually, bringing a successful unfair prejudice claim can be notoriously difficult, particularly in light of the sort of fact specific and complex nature of this particular area of the law. So, a recent case demonstrated that the court will first and foremost look at the constitutional arrangements of the business and will really be very slow to interfere with commercial decisions and judgments that are made within the bounds of those particular constitutional arrangements. So the facts in this case were that the court was asked to decide whether the actions of a private equity investor amounted to unfair prejudice. So the petitioners were certain of the original shareholders in a company that had been looking to exploit the potential of a novel gas safety product. And the private equity investor had come along and made a significant investment into the company, with, as is usually the case, the investment terms being set out in a suite of documents that included new articles of association. And those new articles provided that in certain defined circumstances, which included the happening of an insolvency event, the investor could exercise what were called its swamping rights. So it could serve a notice entitling it to be treated as having 95% of the members' voting rights. So it was able to swamp the votes cast at a general meeting. So those were the rights that were set out in the Articles of Association. They didn't apply from the start, or the swamping rights weren't triggered from the start. Like I say, they could just be activated in certain specific circumstances. So the investment happened initially in 2017, but then it became clear that the company was going to need additional finance. So a share issue eventually took place in May 2019, but that failed really to raise sufficient funds to keep the company afloat. And despite assurances from the original shareholders that it would all be sorted, as they said, the shortfall in the funding couldn't be met. And unfortunately, by August 2019, the investor exercised its swamping rights on the basis that an insolvency event had occurred. So the original shareholders then brought an unfair prejudice petition arguing that the investor had deliberately engineered the insolvency event in order to exercise its swamping rights and therefore gain control of the company. But when it came before the court, the judge dismissed the unfair prejudice petition, and it found that the investor had in fact always acted in accordance with the agreed and professionally drawn up investment arrangements. So the relationship between the parties wasn't one that was based on personal trust. It was purely commercial. And as is often the case in commercial relationships, the parties proceeded on the basis that fairness would be measured by reference to the documentation that had been drawn up by their lawyers and agreed to by them. So the judge was satisfied that all the signatories to the investment documents, including the articles, had been given the opportunity to consider them and to take legal advice on their contents. And the original shareholders were also aware that whilst underperformance on its own was not enough to trigger the investors' swamping rights, their enhanced voting rights, an insolvency event was. And the judge found in this case that the insolvency had been caused by a combination of factors, including a failure to take control of the company's finances, and in fact, a failure by the original shareholders to pay to the company funds that they were legally obliged to pay to the company. So, in these circumstances, the investor was permitted to hold the original shareholders to the terms of the agreed legal documents, and the court said the shareholders shouldn't complain that their treatment was unfair. So, I think that case it illustrates really that the starting point for a court when faced with an unfair prejudice petition will be to ask whether the conduct complained of, so the thing that the petitioners say is unfairly prejudicial, was in fact in accordance with the constitutional and contractual arrangements governing the company. And where the arrangements between the parties are purely commercial, which will generally be the case, then the court's going to be reluctant to take account of any shareholder expectations beyond the scope of their strict legal rights. So, what's a lesson for us to learn from this? Well, I think the parties to any contractual arrangements need to make sure that the legal documentation reflects properly the agreements that they believed have been reached. And that is particularly important, obviously, when there are complex arrangements in place. And the agreed contractual and constitutional documents will establish the rules for the conduct of the company, and therefore, if those rules are followed, a shareholder is unlikely to be successful in any unfair prejudice claim, even if the company ultimately fails as a result of that conduct. So make sure you understand and properly document the bargain that you have struck and agreed to, and then stick to those arrangements, stick to those rules. But if you do, then your possibility for challenge by somebody else that you've acted unfairly prejudicial is going to be minimal. That's it for this month. Hope you found that interesting, and I'll see you next time. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.